And not to mention, I need to know where the
Who
mics
are
are at, so if I gotta turn someone up, I know which mic.
It'll
and they
delay it a
kind of-
little bit. One of the commission
Yeah,
members is
7,
caught in traffic
5,
and will be coming
6.
shortly, but he is not here yet, so.
This is for mic one.
Yes, for your.
Oh, wow.
So
Do you need the camera on the?
It should, you leave that alone, it should be on.
Oh, well, I think I phoned it, Chris, so. Good one.
Yes, please.
Well, you're better than I, Chair.
Just, you know, green thumb for technology, yes. All right.
You got, yeah.
All right, good morning again, and we do thank you for your grace and patience as we navigate the dual meeting setting between online and in person. A lot of times we're waiting to check and verify who's on screen for their attendance and their appropriate case numbers. So again, we thank you for that grace and patience. So this marks our November 20th, 2025 meeting of the Ohio Elections Commission, and we would request the timestamp.
Yes, we are on the record at 10:11 a.m.
Okay, very good. Bill, would you like to go
I
ahead
will
with the roll
gladly
call?
go. Mr. Lyle. Present. Ms. Tavares.
Here.
Mr. Stoutberg.
Here.
Mr. Knight.
Here.
Vice Chair Davis.
Here.
Chair Hagan.
Present.
Mr. Kirschner is absent and he has indicated he had business conflicts that would keep him away from today's meeting.
Is there a motion to excuse Mr. Kirschner
So moved.
in a second?
Second.
Okay, we have a motion and a second. All in favor?
Aye.
Any opposed? Okay, that passes unanimously. Okay, next on the agenda will be the approval of the regular meeting minutes of November 6, 2025.
I'm sorry, Mr. Lyle, go ahead.
So moved.
Second. Okay, we have a motion and a second. All in favor?
Aye.
Any opposed? Seeing none, that motion passes unanimously. Next item of business will be the preliminary review of King versus Sezemplak, maybe a silent Z, case number 2025D-013. Phil, do you care to speak to the
Yep,
case?
Madam Chair, members of the commission, this is a complaint that asserts that the respondent did not include a proper disclaimer on campaign yard signs and a certain campaign handout. The commission did receive a response from the respondent. I have synopsized that for all of you in the outline. Ms. King is online, and she could be seen and sworn. Mr. Semplak, the respondent, is here personally before the commission, and he could be present and also offer any additional comments that the commission would want.
Okay, very good. Mr. Let me see here. Mr. Sunblack, thank you very much for your kindness. You're welcome to approach, but we will also have the online folks as well. So Bridget,
You can just go to the podium at this point.
so if you would like to be sworn in, you're welcome. Sorry.
Please raise your right hand, sir. Do you swear or affirm that the testimony you give today will be the truth, the whole truth, and nothing but the truth?
I do. First,
We should have the,
yeah.
yes, I'm sorry, we got you mixed up a little. If you wouldn't mind waiting, we'll actually have the complaint first.
well, he can just stay there, but yeah, you need Ms. King needs to be sworn as well.
Please raise your right hand. Do you swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Okay, very good. So would you like for the complainant to go first?
Yeah, the complainant should go first. If
If-
she's got anything additional to say to the commission aside from what her complaint states.
I'm sure it won't be long, but if you'd like to say, you're more than welcome to, be welcome to say. Okay, very good. Ms. King, if you would like to proceed, we appreciate that. Thank you.
Sure. Can you hear me all right?
Yes, ma'am.
Okay. So 2 years ago, Mr. Zumplak ran against me, and we noticed when he put out yard signs and his flyer, he did not have the paid for by the committee on his literature. So since this is a local race, I personally reached out to him to tell him that that was the rule, and I'm following it. Everyone else in the race is following it. And he did make adjustments and put stickers on his some of his signs. That was last election. So this election, when his flyers were going out and his signs were put up, again, it was missing that paid for, which is part of, it's listed in the ORC that we need to have it. And so instead of reaching out to him again to tell him he wasn't following the rules, I just filed the complaint.
Okay, very good. We appreciate that. Are there any questions of the commission members for Ms. King? Okay, seeing none, we'll go ahead and hear from you, Mr. Semplake. Can you pronounce it so I say it right?
Simplek, Jeffrey
Semplak.
J.
Okay, thank you. I
Simplek.
heard a few different things. So I
No
wanted to make
problem.
sure. Okay.
And you said we're under oath.
Yes, sir.
Ms. King, when did you talk to me? Or how did you?
Please address the
Commission
commission.
is releasing.
I was never informed by Ms. King of this.
Okay.
Or I would have addressed it at that time. I believe everything I said is pretty well taken care of on that. I did have the paid for. I think I explained it, with the printer and all that. So, other than I don't recall ever speaking to Ms. King about this. That's the only thing.
May I interrupt?
Not at this point, thank you.
Very good. Thank you so much. And we recognize that local races can be as contentious as state or federal races. So we, to all parties, we understand the stress. Okay, very good. Commission members, are there any questions? Okay. All right, seeing none, is there a motion or is there?
You allowed to read dress or no?
Well, if you'd like for her to, we can allow for it.
Okay.
Okay. Okay.
Ms. King, you had something you wanted to add?
Yes, the prior election, I did reach out to him, and that's why he put on some paid for by stickers on his signs after I reached out to tell him that it needed the paid for by logo. And I thought I was being kind by reaching out. That's all I wanted to say. I did not lie about that, and I could go through all my records to find out when I did.
Okay, very good. Are there any questions in regards to that testimony?
And Mr. Richter, Madam Chair, Mr. Richter, your recommendation remains the same?
Yes, my recommendation, Madam Chair, members of the commission, Ms. Tavares, is to find a violation, but for good cause, not impose a fine or refer the matter for further prosecution. After seeing the complaint and reading the response that was submitted, I believe that there's sufficient basis to find good cause in this set of circumstances. But there is a violation of the statute, I believe.
Very good. Are there any additional questions for Mr. Richter? Okay, seeing none, is there a motion?
Madam Chair, I'll move the executive director's recommendation for good cause on, find violation, but for good cause.
Okay, we have a motion, and a second. All in favor? Aye. Any opposed? Seeing none, that motion passes unanimously. Thank you both for your time.
Great, thank you.
Okay, we're going to move on to item number 2 under the preliminary review category. That is Hendrick v. Postage, and it is case 2025D-014. It appears we do have Mr. Postage online. I don't believe there's anyone here in regards to
There
Hendrick.
doesn't, Madam Chair, members of the commission, there doesn't appear, the complainant does not appear to be present, David Hedrick. Joseph Postage is online. We can hear from him. This too is a disclaimer complaint and asserts that the respondent did not include a proper disclaimer on an advertisement in a magazine. There was no original response submitted by Mr. Postage to the commission. So you see my recommendation is to find a violation and impose a fine of $100. Certainly we could hear from, we can have Mr. Postage sworn, hear from him as it relates to his interpretation of the facts and circumstances of the case, and that may impact my recommendation.
Okay, very good. Mr. Postage being present, would you mind being sworn if you'd like to provide comments and testimony? Okay.
Sure.
Okay.
Yes, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, very good. Go ahead and proceed.
So, the complainant, that I did not provide proper, information for when I put this in the Town Saver. So I submitted my stuff to the gentleman for the Town Saver. I had submitted, an electronic version, and unfortunately he grabbed the wrong electronic version that did not have where it said paid for by, city proceeds for school board. So that's how it appears. So it was unfortunately my fault. I thought I
I'm
had
having
told
a
him.
hard time understanding
to-
that. Is anybody else?
I can understand him. It's just broken up. Sounds like he maybe submitted multiple and one was used that didn't have the disclaimer.
Yes, that my signs have, but there was a two-sided thing. What happened was is he submitted the one that didn't have the disclaimer on it. And not realizing that until after it got printed.
Very good. Are there any questions of the commission members? Okay, seeing none, is there a motion at hand?
Madam Chair, I would update my recommendations and say there's still a violation. But considering the respondent's statement and the fact that he relied on someone else to put the materials into the magazine, and at least according to him, the person doing so put one in that did not have a proper disclaimer on there. My recommendation now would be to find the violation, but for good cause, not impose a fine or refer the matter for further prosecution.
Second.
Okay, we have a motion and a second. All in favor?
Aye.
Any opposed? Okay, seeing none, that it passes unanimously. Thank you, Mr. Postage, for your testimony. Okay,
Thank you.
You're welcome. Okay, moving on to the reconsideration category. Item number 3, case 2024R-210. Bill, do you care to?
Madam Chair, members of the commission, the staff went through their preparatory work before sending along materials for collection by the Attorney General's office. It was brought to their attention that the respondent in this particular case had filed their report with the Board of Elections, although it was late. And so my recommendation, Madam Chair, members of the commission, is to reconsider the matter, vacate the previous imposition of a per diem fine, and instead impose a fine of $150. I'd be glad to answer any other questions the commission may have.
Very good. Yes.
Madam Chair, just one question of our executive director, Phil. Was this the first violation or had there been others?
This looks to be a first time violation.
Okay. And you're still comfortable with the 150?
Yes, no response was ever submitted.
Okay.
We informed the respondent that the matter would be reconsidered. So the original decision was made in May 30 of 24. The report was submitted in September of 25. Notice was provided as it relates to commission meeting today. No response was ever submitted, and so that's the basis for my $150 fine amount recommendation.
Thank you. Madam Chair, I'll move the recommendation of the executive director.
Very good. We have a motion and a second. All in favor?
Aye.
Any opposed? Okay, that motion passes unanimously. Okay, moving on to the motion for frivolous finding pursuant to revised code 3517.155E. Case 2024G-033. It appears that we do have Mr. O'Brien here in person to represent Krensky. And then also in representation of Bennett, we have Marty Sweterlich. Okay, so if you would both like to come up, I appreciate that.
Madam Chair, members of the commission, this matter was originally decided by the commission, and the matter was dismissed in December of 2019. We received this request for attorney's fees in May this year from Mr. O'Brien, indicating that it was his belief that the matter was frivolous and that attorney's fees should be paid by the respondent. I would like to hear further from Mr. O'Brien and my general recommendation as it relates to frivolous matters is, unless it's really egregious, is to not find a matter frivolous. While certainly the complaint could have been better at the end, the direct could have been more appropriate, let's say. There were allegations included in there as it related to 3517.105, the independent expenditures statement, or the independent expenditures item in the revised code. But certainly we could hear further from Mr. O'Brien as it relates to his motion and from Ms. Sweatterly as it relates to the Bennett's petition.
You're welcome to have the complainant here and the respondent here, and obviously, Mr. O'Brien, feel free to be sworn, or well, you don't need to be sworn in, feel free
Yeah.
to share.
Thank you, Madam Chair. Ron O'Brien, 17245, on behalf of the respondent. In this case, I think it's important to look at the history. Started more than a year ago. It was a November 24 election, and in October, the complainants filed a complaint with the Elections Commission merely because a citizen had organized a group and was trying to oppose a levy. And they filed a complaint. It was apparent from the complaint that they had communicated with someone, whether it was council, a neighbor, or the commission itself. But in bright red letters on the complaint and in bright red letters on the commission's website, it says that all complaints shall be sworn. That means under oath. It explains you have to see a notary. This was not a sworn complaint. So facially, the complaint was defective. When you get into the merits of the complaint, as the commission so found, and I have their minutes and it's attached to my motion, the commission itself by a 6-0 vote found that the complaint was insufficient and that there was not a sworn statement in compliance with the statute. I filed the motion pointing that out. We heard nothing. We heard nothing. Today is the first day either the respondent or through counsel has appeared in front of the commission. The commission scheduled the motion to dismiss. They didn't answer the motion to dismiss. I had to come down here. This man in Westerville had to accrue attorney fees merely because it's defective. On his face, complaint was filed. And that's not fair to him. And it's not fair to the public to make them defend a claim that on its face is defective. In fact, respectfully, it shouldn't even been sent out when staff would have noticed that it was unsworn. But in any event, having done that, he had to accrue the attorney fees, didn't answer the motion to dismiss, didn't appear the court, but the commission dismissed it. Thereafter, I filed this motion for attorney fees as the respondent thought that was the only fair thing to do. And I agree with him. And I think, as Mr. Richter said, that the commission maybe has hesitated in the past to oppose attorney fees, but I sat through a hearing that this commission had in Scott Hubay versus the commission where you did award attorney fees. And that was a case where a group in Upper Arlington had opposed a levy. And all people who were a member of a Facebook group were respondents and had to defend the case. And the commission said, that's not fair. You filed a complaint without any merit, and these folks had to accrue attorney fees defending themselves. The commission awarded attorney fees. And I think this case is exactly the same, if not worse, because the respondents in that case showed up, the complainant showed up. Here, we've seen nothing from the complainant from day one. They didn't answer the motion to dismiss. They didn't answer a motion for attorney fees. And only yesterday, a lawyer I know called me and said that someone had reached out to them in connection with this matter now that the commission was going to schedule the attorney fees request. So I think that in fairness to the public and to this particular respondent, that the commission ought to recommend the award of attorney fees in the case. I would add it is not anywhere near the kind of attorney fees the commission awarded in the Hubay case. But that would be a matter to come up at the second hearing. So I guess I really have nothing further to add. I appreciate your attention and happy to answer any questions.
Very good. Are there any questions of Mr. O'Brien?
I have one, Madam Chair. I just heard what you said about, I understand this is a motion to have the hearing. Can you tell us how much money we're talking about?
I think it would be counting the time that it is involved in coming down here again today, probably in the neighborhood of $1,000.
Thank you.
And it was 4,300, just for your information, that the commission awarded in that Facebook case from Arlington.
Thank you, Mr. Lau. Thank you, Mr. O'Brien. Any other questions of commission members? Okay, very good. Thank you, Mr. O'Brien.
Okay, thank you very much.
Appreciate it. Ms. Sweatterlich, you're welcome to be sworn in to testify. She's an attorney. Oh, she's an attorney. Then you do not need to be sworn in. Done your due diligence in advance.
Ron and I go way back. And I would let the board know, Ms. Bennett is here if you want to swear her.
Okay, if she cares to testify, then we will.
Okay.
Thank you.
So I'm Marty Sweterlich. I am bailing at retirement, so here I am. And just for the record, I'm here as a volunteer. My client is not incurring any legal fees from me. My client got notice of this hearing on Tuesday. It is now Thursday. I learned about it last night while I was sitting in the parking lot at the Shot getting ready to go to a basketball game. We won, by the way. So I haven't had a lot of time to delve into this. Couple of points I want to make. First of all, Ms. Bennett and her husband were volunteers for the school levy campaign in 2024. And they again volunteered in the last campaign whereupon Westerville actually passed an income tax. During that 2024 campaign, Mr. Krinsky was organizing opposition to the property tax levy, which he's certainly free to do. My client noticed that and got information from him. He was sending out blanket inquiries to his followers to solicit money. Those documents, which were part of the, part of the complaint she filed, showed that he was not only asking people to write out the checks to him personally, but he was also telling people he didn't want to bother with creating a political action committee. Now, as I understand the law in Ohio, if you create a ballot issue, if you're going to oppose or support a ballot issue, there are certain requirements you must meet. And the levy committee at the time was meeting those requirements. My client felt like this ought to be a two-way street, that the opposition ought to be complying with the rules. She's not an attorney. Her husband's not an attorney. She thought this process was so that citizens could help keep elections fair and equal. So they filed the complaint. Went before a notary. Instead of swearing, he acknowledged. It's on the paperwork. Can't argue about that. If I had been here for that hearing, I would have made some arguments, but that's, we're past that point. The issue here today is, was this a frivolous complaint? No. Clearly, Mr. Krinsky had not created an entity, had not filed any paperwork, it had not named a treasurer, had not done any of that until this complaint got filed. I listened to the transcript of the hearing of the last hearing on this morning. I got a link to it and I was able to listen to it. And my friend Ron O'Brien, Mr. O'Brien, did state in front of all of you that Mr. Krinsky had, subsequent to getting the complaint, seeing the complaint, had filed the appropriate paperwork and got his group, straight with the election law in Ohio. So was this a frivolous complaint? No. It had a basis. It had merit. It was filed by a citizen volunteer who was working on the campaign to support the schools in Westerville. So it just seems to me that in fairness and for equity, this board should not require her to pay anybody else's legal fees when the complaint she filed was a good faith complaint. It failed on a technicality. Let's face it. We do not send all our citizens to law school. We put a process out there. They followed it. Did they do it correctly? Apparently not. But that doesn't make the complaint frivolous. I'm happy to answer any questions.
Are there any questions of the commission members? Seeing none,
Thank you for your time.
Absolutely. And are you good? Okay, very good. Mr. Bryan, I assume you were hoping to respond.
If I may say, I think Mr. Krinsky himself is obviously a citizen in Westerville. And what bothers me about this case is he has chosen to come down here today, 14 months later. If she'd have come down here a year and 2 months ago, this case would be over. It would be done. She could have sworn, Mr. Richter could have sworn her to her complaint. But in addition to the failure to swear, as the minutes will reflect, the complaint itself was defective because it referred to wrong statutes. And at least in order to avoid further issues, Mr. Krinsky, in a self-protective mode, did file a campaign finance report with the Board of Elections showing expenditures of about $1,000. And that money was spent on the campaign. Any suggestion that he solicited money and went into his pocket is just not accurate. And at least he was trying to exercise his citizen rights and has accrued attorney fees in the process. And I think that the commission should recognize that and award attorney fees at a subsequent hearing. So I thank you for your attention.
Okay, are there any additional questions for Mr. O'Brien? Okay, seeing none. Is there any update for your initial thoughts, Phil?
No, again, I haven't really made I don't think a specific statement, but I always view frivolous finding cases to be egregious, I guess, and it becomes a matter of whether the commission believes that to be the case in this set of circumstances.
Madam Chair, I have a question for Mr. Richter. So how, in the life of the commission, do you know how many frivolous claims have actually been made?
It's been a while since I've looked into that issue, but my recollection is when we dealt with this in the Kool-Aid case that Mr. O'Brien referenced, I think at that point, there had been like 6 or 7 where we actually took the effort to make a finding of a frivolous finding and move forward. Fairly regularly, when a respondent puts in their response, they will reference the frivolous section as a part of their response. And then I recommend the commission ignore it or not make a finding that the matter be found frivolous. So it's regular, it's often, not all the time, but regularly included in a response by a respondent, but only 6 or 7 times at that point.
Because this was subsequent to the complaint.
Correct.
Do you know the date of the case? That was just curious.
It was in the early 21s, I think. 2021, 2019, 21, 2022.
I don't recall. I've been on almost 4 years.
It was before, okay, it's before your time on the commission.
Okay, all right. I was gonna say, I don't remember us ever granting a frivolous case.
Yeah.
Okay, all right, thank you.
I mean, I can look it up.
Here on my phone, if that's December 28th of 2023.
Say, I remember it.
Well, I don't.
So I sat through the hearing, it's but I.
Okay. Oh, that's fine. Thank you.
I'd like to make a motion to deny the motion. The motion, what is the exact motion?
For frivolous finding pursuant to RC 3517.155.
Yeah, I wanted to motion to deny that.
Is there a second?
Second.
Okay, there's a motion and a second. All in favor? Aye. Any opposed? Okay, that motion passes unanimously. Okay, thank you both very much for your time.
Thank you, appreciate it. May I have a matter of personal privilege, Madam Chair? And I want to thank all the commission members. I know this is close to the end of your service. And as you know, I have appeared here somewhat regularly the last probably 4 years. And I have always felt that you did a great job. I thought that you, as dedicated public service, had a tough job to do. And I think there's been some unfair criticism down this stretch, I would add. And I just want to thank you for your service. And I know you probably have 1 or 2 more meetings, but hopefully I will not be here. So again, thank you again for your service and good luck.
Thank you, Mr. Barber. Thank you.
Okay.
Do you have a copy of your business card?
Thank you. Not,
Okay, very good. We are moving on. Okay. Okay, a final item for our consideration is the hearing. It is case number 2022G-014, item number 5. Mr. Hicks is online, and we also have representation by Rob Tudor of Tucker, I apologize, can't read my own writing, of Susan Jones, who was the treasurer of the Freeman Campaign or Freeman Campaign Committee.
Correct. Madam Chair, members of the commission, this matter was set for hearing vote. In the intervening period, we received this motion to find that res judicata is present that was filed by Mr. Tucker on behalf of Susan Jones as it relates to this matter. Mr. Tucker obviously is here on behalf of Mr. Jones. We could hear from him further to address his motion. And then we could have give Mr. Hicks the opportunity to address the commission as well.
Sorry, excuse me, folks.
From his perspective. So, Madam Chair, I'll leave it up to you, but if you want to hear from Mr. Tucker, it's his motion, so he should go first.
Okay, very good. Absolutely. Mr. Tucker, we'd love for you to approach and present.
Thank you, Madam Chair, members of the commission, Mr. Richter and staff. Good morning. My name is Robert Tucker. I represent Susan Jones, who is in her capacity as the former treasurer of the committee to elect Alan Freeman. And we are asking that the commission dismiss this case based upon res judicata. And I will note that to date, we haven't received any opposition from Mr. Hicks to that motion. This is the third complaint filed by Mr. Hicks relating to transactions from the 2020 primary race for the 66th district for the Ohio House. The first complaint went to a full hearing before this commission over a period of several days in October and November of 2021. Following public deliberation on December 16th, 2021, this commission issued a final decision finding a violation of the Ohio Revised Code and fining Mr. Freeman and the committee to elect Alan Freeman $50,000. Notably, the commission could have, but did not require Mr. Freeman or his committee to file any amended reports relating to those transactions. That final decision was appealed to the Ohio Court of Common Pleas as well as to the 10th District Court of Appeals and was upheld. Mr. Hicks then filed a second complaint in 2021, which also related to transactions from the 2020 primary race. In that case, Ms. Jones, my client, was actually added and named as a party to that case. Now, the commission held an initial preliminary hearing on that matter on January 30th of earlier this year. But due to some motions that were filed at the last minute, the commission adjourned that preliminary review until April 24th, 2025 to allow time for Mr. Hicks to respond to those motions. At that April preliminary review hearing, however, the commission dismissed the 2021 action based upon the legal doctrine of res judicata, which states that a party cannot relitigate claims or issues that were previously litigated to a final judgment. Because the commission found that the claims and issues that were litigated to a final judgment in the 2020 action, or that could have been litigated in that 2020 action, were the same as asserted in the 2021 action, Mr. Hicks was barred in that case from litigating them there. Thus, the 2021 action complaint was dismissed, including as to Ms. Jones as the treasurer of the committee. Now here we are again. And Mr. Hicks seeks a third bite at the apple through a third complaint against Ms. Jones and Freeman's campaign committee, again complaining about the same transactions that he believes were not properly reported from the 2020 primary race. But if the 2020 action was dismissed based upon res judicata, then so too must this action, which again relates to the same transactions from 2020. Now, presumably, Mr. Hicks is going to argue this case is different. This isn't about the 2020 reporting, because in his belief, it relates to a failure to report these transactions in a 2021 annual report, as opposed to the 2020 pre or post primary reports. But that position fails for three reasons here. First, these are the exact same expenditures and contributions that were at issue in the 2020 and 2021 cases. The commission already issued a final decision on the reporting of those transactions in the 2020 case. Again, the commission could have, but did not require amendments of any of the 2020 reports. Thus, the legal doctrine of res judicata now bars this commission from re-litigating the reporting of these transactions in a third case and now in a different report. That is exactly what res judicata prohibits. It prohibits this very type of piecemeal litigation that Mr. Hicks is trying to pursue through his third complaint before this commission. Second, the 2021 annual report would not be the proper place to report these transactions from the 2020 primary. Rather, the 2021 annual report requires the reporting of transactions that had occurred since the date of the previous report, which in this case would have been the 2020 annual. meaning it required reporting of transactions that happened in 2021. None of the things that Mr. Hicks is complaining about in this complaint happened in 2021. The 2021 annual report is accurate. And Mr. Hicks hasn't pointed this commission to anything that happened in 2021 that should have been reported in the 2021 annual report. And again, to the extent we're talking about transactions that happened in 2020, that's exactly what was addressed by this commission in its final decision in the 2020 case. He can't relitigate them now under the premise of they should have been reported in a later report when that's not factually or legally accurate. Third, Ms. Jones, as I think the commission may recall, was terminated as the treasurer of the committee on December 13th, 2021. So if there are any corrections that needed to be made to any of these reports, she's no longer in the legal authority to do that. What would be required under Ohio law would be the candidate has to appoint a new treasurer, and that person would be responsible for making any corrections to the report. So in sum, the issues relating to the reporting of these transactions from the 2020 primary were already addressed in 2 prior cases. One of which went to a full hearing and a final decision, and the other that was dismissed based upon this legal doctrine of res judicata. The commission dismissed the 2021 action based upon res judicata, and this matter warrants the same result. Mr. Hicks can't simply repackage his claims to now say these transactions must have been reported in the 2021 annual report. Not only is that factually and legally inaccurate, it is exactly what res judicata prohibits. For these reasons, we ask that the commission dismiss this action, and I'm happy to answer any questions.
Okay, very good. Thank you, Mr. Tucker. Are there any questions currently for Mr. Tucker? Okay, very good. Thank you. Seeing none, Mr. Hicks, if you'd like to be sworn, we would be glad to hear your testimony.
Raise your right hand.
Hold on. Are you still muted, Mr. Hicks? It looks like it's reflecting it on the computer.
Yeah, he is.
Yeah, you're muted.
You're muted. Muted. You're muted on your end.
Yeah, you just gotta unmute.
All right, do you hear me now?
There you go. Yep, okay. Sorry, go ahead.
Please raise your right hand. Do you swear or affirm that the testimony you, please raise your right hand. Sorry, I can't see it. Thank you.
It's gotta be on screen for us here in Columbus.
Do you swear or affirm that the testimony you give today will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay, so I didn't file a response to this because I think the fix is in on this one. But any event, I want to address some of the points here that just because I think some things were left out. In the course of case 2020 G019, there were some specific expenses that came to light that were never part of that case, such as Mr. Caraway's expense invoice, the calculation of what should have been the in-kind contribution from the ORP for the services of RJ Mancini. And if people would go back on this commission and look at that, but probably you guys are about out the door, but if you go back and look at that, you'll realize those
Mr.
things.
Hicks, no commentary to that regard. Thank you. Just keep to the case.
Okay, I'm sorry. I think I'll say what I please at this point. Okay,
Well,
so.
I think I still have the gavel until the end of the year.
Well, then gavel all you want. Okay, so the point being that there were a set of things that got testified to while Susan Jones was in the room where she first became aware of them during the hearings of 2020 G19. And I'm talking about things that are not the $140,000 that was adjudicated in that, which dealt with media buys done by JPL and Associates that were never reported anywhere. And it's also not about the print part, which back in that case, Mr. Freeman wished would be done in a different case, but then when it became a different case, then he wished that it would be res judicata. So there are some specific expenses that were testified to, such as Mr. Caraway's expense invoices, such as Mr. RJ Mancini's ORP time, that was even calculated during the hearings of how much should be reported. Actually, in the hearings in 2020 G19, part of that whole discussion with RJ Mancini was coming to an exact number. It was like $400 and something that should have been reported. Ms. Jones became aware of those expenses during that hearing. They were not part of the hearing. The hearing was limited by the commission to only be on media invoices, which dealt with strategic media partners and what they did. So just so most of you weren't on the commission at the time, a few were, Ms. Tavares was, I believe, is what happened was, just to lay this out, is on December 7th, 2021, the commission held a deliberation in case 2020G019. That was after the hearings took place. It had a deliberation meeting, public deliberation. On December 13th, Ms. Jones and the campaign knowingly filed a false and inaccurate annual report and termination. They had found out about the events. I think when it relates to expenses, you report them, you could go back and revise, but you can also report or should report when you become aware of them. And she became aware of those particular expenses, the Stephen Caraway expense invoices, the RJ Mancini in-kind contribution of time from the ORP that had not been reported. On December 13th, 2021, so basically a week after the deliberation, Mr. Bray, Mr. Freeman, and Ms. Jones filed an annual report and termination specifically to avoid accountability in case 2020G19. Those of you that I think one of you, Mr. Richter will remember this. What happened was they filed this final report and termination and then filed a motion to dismiss 2020G019 that the commission had no authority anymore because the committee had been terminated. The commission went ahead and actually had the order in that matter. So the motion to dismiss was filed on December 15th. So December 7th deliberation. So they knew what was coming because in the deliberation, the commission agreed there'd be a $50,000 fine, et cetera. And Mr. Richter was supposed to put it in writing for approval on a meeting on December 17th. On December 13th, Mr. Richter, Mr. Bray, Susan Jones, and Alan Freeman filed an annual report and termination. On December 15th, they filed a motion to dismiss the case 2020G19, claiming that there was no jurisdiction of the Ohio Election Commission. And then on December 17th, the order was issued from the Ohio Election Commission in that matter. So the biggest point in this case that has nothing to do, but like I said, I think there's certain outcomes because you guys are about out the door. And this involves Winterset CPAs. That was the CPAs for all of the householder candidates who did not already have a treasurer, as well as big names like Matt Huffman, Robert Sprague, Keith Faber, Dave Yost, and even Jason Stevens. So this firm is connected. Miss Jones is connected, and I get that. And you guys, I think, have gotten a message about stepping over the line and with having any notable enforcement.
This is inappropriate. We've received 0 messages.
Okay, thank you
If you
again.
if you don't have facts, please do not testify as such.
Okay, so he just testified to a lot of things that I don't think it's not an evidentiary hearing. Okay, so we're not trying, so he said a lot of things that I don't remember anybody saying, is that a fact? Is that a fact? So the point being here is that this matter is about what was a knowing plan against the commission to get out of responsibility in case 2020G19. The issue specifically is that there were a set of expenses that were identified during the hearings that were not part of the hearings that were testified to by Stephen Caraway. They were testified by RJ Mancini and Rob Secor from the ORP. And then those expenses that were first known to Susan Jones sitting in the hearings at that point in time, per her, were then never put on a campaign finance report. And she filed the December 13th, 2021 finance report and termination, trying to get out of responsibility, and did not disclose those transactions to which she had personally heard the testimony of. So, you know, I think that this body and Chair Hagan can start gaveling and so forth is about out the door. And the issue is a lack of credibility in a lot of cases. So here we are again. You've got a powerful accounting firm that is the accounting firm for many of the top political figures in the state. You have a treasurer that anybody that was involved in that 2020 G19 hearing know they had a knowing plot to try to get out of responsibility by filing a December 13th, 2021 annual report and termination, but they screwed up in that she filed a report that did not reflect expenses that she had become aware of. By the way, this was the first report after the whole hearings and the whole process. There had been no intervening report until this report. So at a minimum, those expenses that were for Stephen Caraway's expenses and for the ORP in kind, those should have been on this report. So the December 13th, 2021 report, which was not at all part of the hearings relating to 2020 G019, that report was not complete and was not accurate. It did not contain information that had come to light to the treasurer during the course of that hearing. Okay, so and specifically, if you look in the actual complaint that was filed, Stephen Caraway's expense invoice is Exhibit 4. The RJ Mancini computation, you would have to look at the transcripts from 2020 G19. And so those alone here are issues that are ripe, fresh issues. But by the way, I'm also interested in that what was said is that if you, and this is beyond this, but I'd be interested to have a comment on the comment that unless you, the commission, specifically called for corrected reports to be filed, that there's no obligation on the part of a candidate to file corrected reports when you found that the reports were incomplete and inaccurate. And the reason why I think that's such an important issue beyond this is that we know where all this money came from. The Larry Householder organization, the invoices were paid by JPL and Associates, which is a corporation. And so a lot of times these things are getting, I told people on the original Friedman thing, I saw that as, okay, it's good, but it's kind of a cover up, because the real thing here is that all this money came through a corporation. And so I'm very interested in the notion that unless you guys specifically required somebody to file corrected reports, even when you find the reports were inaccurate, that they don't have to do so, because that would be another example of how this commission has played a role in sweeping under the rug that illegal corporate contributions. So I don't think, I think you guys have a perspective because you're about out the door, but
Mr. Hicks, it's just about basic civil dialogue. You don't actually have to insult us every other sentence. You can get your statement and your ideas and thoughts.
Am I allowed to insult you guys, or are we not permitted to insult you?
No, it's inappropriate. Whether there's a door or no door, there are civil proceedings taking place. It is completely and utterly inappropriate to treat us as you're treating us. Do we treat you that way?
Well, I think it's completely inappropriate to have participated as a body in the cover up of the entire Larry Householder episode, except for me. And I love the facial expressions. So those are my comments. I think this is a fix. And I think this commission, I think what's very odd, it's unbelievable when you get a time when Dave Yost, Secretary LaRose, and Chris Hicks agree on something. So do what you're going to do, because it's part of the pattern of how this commission walks out the door. But the reality is that the December 13th, 2021 report was not part at all of 2020 G019. The treasurer found out about expenses during that hearing that were not even part of the hearing, and specific to that I will highlight that were testified to by former member Stephen Caraway were his expense invoices that should have shown up on a campaign report. And in addition, the RJ Mancini in-kind contribution from the ORP that never showed up anywhere. And I think if you check, somebody could go back and revise, but you report something when you become aware of it. And she became aware of it during those hearings and then did not file it on the December 13th, 2021 report and termination that was a knowing plot to try to escape oversight by the Ohio Election Commission. So I think the motion should be denied, but I also think I know what's going to happen.
Thank you for your comments and your testimony. Are there any questions of Mr. Hicks? Okay, seeing none. Is there, do you care?
Just one very brief rebuttal point. I think we just heard admission that all of these things that are being raised in this case were stuff that was testified to and was part of the 2020 case. And I'll read just really quickly directly from the final decision that this commission issued in that 2020 case. That says, this is a quote, that there was provided to the Freeman campaign a variety of in-kind contributions that encompass the production and airing of television and radio advertisements and personal assistance to the campaign committee, including a campaign manager, that would be Mr. Mancini, the expenses that he's referring to here, and media consultants that likely included at least JPL and Associates, Constant Content, strategic media placement, that's again the same $137,000 invoice, and Stephen Carolyn. All these things were at issue in the 2020 case. The commission already ruled on it. That's exactly what res judicata prohibits, is these now being relitigated again under the guise that this must now have been reported in the 2021 annual report. That's not even legally or factually accurate as to how that would be accomplished. So that's it. Thank you.
One name you
Commissioner,
didn't
are
hear
there
in what
any
he just said
questions?
was.
Hold on. Are there any questions of the commission members in regards to that? Okay, very good. Go ahead, Mr. Hayes.
So one thing he failed to mention is Turn Creek Consulting, which was Stephen Caraway's company with the expense. And I don't know if he mentioned ORP in-kind contributions that I have highlighted again and again. There were two things that I keep highlighting that in this discussion that were known. And so the point is, it's also, I think, very interesting, the notion that somebody, a treasurer, becomes aware of something, and let's focus on the two things that I've brought up, the Churn Creek Consulting expense invoices and the ORP in-kind contribution, and does not then report them, does not put them on the next filed report when they became aware of them. This is an interesting dichotomy, that the argument here is that because those things that were not part of that case, but came up during the case. So if something came up during the case, like somebody walked in the door in the room and said, hey, I gave you $50,000, you're saying there's no obligation to report it? So the reality here is that it makes no sense that campaigns are not always required to correct inaccurate and incomplete financial statements, but that appears to be what was said. And I'd be interested to hear the commission comment on that. But these expenses, the Churn Creek Consulting and the ORP in-kind contribution, are beyond the scope of anything that was part of the order in that prior case. But also, they've never been reported on any campaign finance report. And this whole body is supposed to be about accurate and complete campaign finance reports. So the December 13th, 2021 report, that was, I'll remind you guys again, a plot to evade accountability to the Ohio Election Commission. That report was not complete or accurate. And that report was not part of anything in 2020 G19. Thank you.
Okay, thank you very much. Are there any questions of the commission members? Okay, seeing none, is there a motion?
Madam Chair, I'll move a motion to find that res judicata is present and dismiss the complaint.
Second. Okay, we have a motion and a second. All in favor, signify by saying aye. Aye. Any opposed? Okay, that motion passes unanimously. Okay, thank you, gentlemen, for your time.
Thank you. And thank you guys for your service.
Thank you. Appreciate it. All right, very good. Other business is just that we do have our next meeting coming on December 4th. And then the final meeting on the 18th.
Correct.
And Chair, on our final meeting, is that when we're going to have our holiday soiree?
Yeah.
The reason I asked
don't know
is I
about
ran into former Commissioner Beatty at the airport and told him that I thought we were gonna have something like by all of the former commissioners.
Mhm, absolutely.
We normally try to do this.
Very good. Yeah, I think that's awesome.
Wonderful. Thank you. Well, I'll move to adjourn.
Second. Okay, we have a motion and a double second. Who was first? I don't know if that's. I think it qualifies it. So all in favor? Aye. Any opposed? Okay, seeing none, this meeting is closed. Thank you. Thank you. Hey, guys.
The time is 11:05 a.m. and we are going off the record. Stand by.